SJC 12806, Commonwealth versus James Paige.
Okay, Attorney Kelly, good morning.
Good morning, Good morning, Chief Justice, and Your Honors. If it please the court, my name is Brian Kelly. I'm representing the defendant, James Paige. I did have 2 points of clarification for the court before I really get into the other. One is that there was a or a typo, I think, on one of the citations on a case called Commonwealth versus Tony. It's in the appendix and in at least one of the beginning cites. It should be 385 Mass 575, not 585. So the point of clarification, I apologize for that. The second point is that I have taken this case over. Attorney Leslie O'Brien drafted the brief and has since retired, so they got me to come in and argue this case. I've reviewed the transcripts, the briefs, the case law, and while I'm not conceding or waiving any of Attorney O'Brien's arguments, I would like to concentrate, if the court will permit me, on 2 what I think are the strongest arguments, that being the argument number 3, the ineffective assistance of counsel regarding the consciousness of guilt instruction, and the denial of the mistrial, number 5, was the argument. As to the ineffective assistance of counsel, in this particular case, actually the Commonwealth requested a consciousness of guilt instruction, and initially the trial judge said that actually wasn't even appropriate because it had to do with the...
Is it the issue that the consciousness of guilt instruction giveth and taketh away? And that's why the defense attorney doesn't want it, because and have we had cases where we said that's ineffective assistance of counsel, where some of it's good for the defendant, some of it's really bad for the defendant?
I would agree, but I think in this particular case, not taking my point in ineffectiveness in this particular case by counsel, well, basically it was offered to him, declining it, objecting, declining it, and then of course in the motion for new trial, saying that was a tactical, which is normally the kiss of death on these cases. Of course, we're arguing manifestly unreasonable. And I do think it is manifestly unreasonable, Your Honor, because if you, following both the Tony case, which basically sets out the instruction for consciousness of guilt, but more so the Morris case, Commonwealth versus Morris, which kind of goes into an explanation and I think makes the point for the defense in this particular case. The Morris case basically said there's 2 benefits to a defendant in hearing a consciousness of guilt. One is to reinforce the theory that defendant would probably want to put off, and that there's other reasons.
But why would the Commonwealth want, why would the Commonwealth, I apologize.
That's okay. I'm a little hard of hearing on it. I apologize.
Well,
If I do this, I'm not trying to be
French.
French.
That doesn't help either. But why would the Commonwealth want the instruction then?
I asked myself that question too, Your Honor. I think, well, it's one of these, it is, as Morris says, a balancing test. So it's clearly, they've got the vernacular, they've got the guy dead to right. I mean, he says he didn't have sex with her. Yes, he did. DNA. So I think the Commonwealth would be arguing, why else would you deny this? So I can certainly see the Commonwealth's point. But I'm sorry, Your Honor.
No,
But in this particular case, the Commonwealth actually in their brief on page 34 of their brief actually cites the language that's used by the trial counsel in his closing. Basically what he says, people do that. That's what people do, they say things, which is the exact same thing that Morris says. And again, as we've all been in front of juries and judges, I think the case where you have an attorney's going to get up, and there are people that out there will say, oh, sure, the attorney's going to say anything. And to come in and say, you know, there's all sorts of reasons why you wouldn't want to lie to that. But to then have the judge give the imprimatur of credibility to that by saying, you know what, there are other reasons why people do that, I think, I can't put a better word, reinforces that argument for the jury. So I think to walk away from that would be manifestly unreasonable, especially given that, one, as I said, they've got him dead to rights. There's no way he can say, oh, he made a mistake. But two, defense counsel brought that up exactly. He went ahead, and it's not like he said nothing on it, and the judge brought some new information. That's exactly what he did. So I would say this hits right on point.
Can I ask you, and I know you do want to focus on this, but on issue number 1, sufficiency of the evidence, Mr. Kelly?
Yes, Your Honor.
There's a case that wasn't cited, and recognizing that you didn't write the brief, I don't believe this case was cited by either the author or the Commonwealth. It's Commonwealth versus Cessny, SCESNY, if I'm saying that right, 472 Mass 185, that deals with whether or not there's a reasonable inference or evidence of a sexual assault based upon the way a victim is found with clothes off and the like, which I think might help you out.
Well,
I recognize you're not conceding issue number 1, but can you briefly go over why the presence of the seminal fluid plus the way she was unclothed would lead to an inference of consensual sex?
Explain why it would not show the aggravated rape?
Correct.
Well, the cases that there were there, that Sharamond case and the Maz.
And I'm going to give you an opportunity to address that Cessny case in the 60 now.
Thank you, Your Honor. I was going to ask you if I could do that. I appreciate that, Your Honor. Thank you to the court for that. But in the cases that were cited in the brief, that Sharamond case where there were background issues of the victim threatening, the defendant threatening the victim's new boyfriend, an abuse prevention order, a potential reconciliation that was rebuffed, there was hostility there. The Maggiergio, and I apologize if I mispronounced that, talked about abrasions to the victim's genitals and that she had apparently wanted money before she had sex. None of that is an issue in the Paige case. Now, what hurts the Paige case, of course, is the denial and the fact that the only witnesses that came forward, said that neither defendant or victim knew each other. Again, why other things weren't brought out, I can't address that, Your Honor. But the Commonwealth brings up issues, and I think they use the term the circuitous reasoning. One usually does not kill someone after sex, but since she was killed, then it must have been rape. I don't necessarily respectfully follow that logic to its nth degree.
That's what Cessny, I think, addresses, and you give us an opportunity to get your reasoning on that. And I've cut you off on an issue you didn't want to talk about, so if you could go to the next issue.
Oh, thank you, Your Honor. Appreciate that. The second issue that I wanted to touch on is, well, actually, I did want to just one last little point on issue number 3. The Commonwealth, in their brief on page 30, claims that the prosecutor did not argue that the inconsistent statements made by the defendant was consciousness of guilt. I would respectfully disagree. I think it's a matter of semantics.
They just didn't use those words.
Transcript 765 Volume 7, page 65, the district attorney calls the defendant's statements a lie and said, I'd like you to compare the defendant's reaction versus the other witnesses or other people that we interviewed's reaction. And I would respectfully say well, I leave it, of course, to the court's discretion, but I think it was something that should be looked at. I would respectfully disagree that that wasn't argued, at least in some sense. But even if it wasn't the case, that we didn't have to bring in the issue of the balancing test, I think the key to the consciousness of guilt has to do with the reinforcement.
But that cuts the other way as well. So I think the perfect analysis of a consciousness of guilt instruction is, as Justice Scaziano said, it giveth and it taketh away. So it's quintessential strategic decision. Now, if the judge gives the consciousness of guilt instruction, it's not going to mean anything unless the judge identifies the nature of the consciousness of guilt. And here, the judge would be basically saying that you can consider that he said that he didn't have sex with her, and you can consider these inconsistent statements. Now, maybe on balance, some lawyers are going to think that's the best strategic choice, but it seems to be right in the bailhouse of judgment by a lawyer as to what to do with that instruction.
Well, I agree with you as far as the point where I said, in this particular case, there is no way around the fact that Mr. Paige lied.
I know, but you just said you want the judge to reinforce, that there might be innocent reasons, but maybe trial counsel didn't want to have the judge reinforcing the key to the Commonwealth case.
Well, I would answer that, Your Honor, this way, in that would be fine if trial counsel never brought up that, but it's the exact argument that trial counsel brings up. In fact, he says, there's lots of reasons why he would not. It's a 27-year-old murder case. He doesn't want to be involved because that's what people do, is what he said. And I think having that, Your Honor, if I didn't have that language, I think you would be exactly correct. But I would argue, Your Honor, that because it seemed to be almost on point, that why would you not? It just seems, if you've got it, use it. And as I said, I think lawyers tend not to be trusted at times, and juries might be skeptical, but when you get a judge that says, what he said is right, I think that goes a long way. If I may, onto the mistrial, this, of course, was the unredacted video that was shown, and after several seconds into it, Mr. Paige says something about more cases.
There's a long curative, as Judge Muses want to do. Didn't that take care of it?
Well, ordinarily, I would say yes. However, what I would say is the problem with I have to say, I wouldn't have normally found, in fact, I don't find anything wrong with a curative. But what I do find something wrong with is the delay. And all of the cases, I believe, that are cited in the defendant's brief and by the Commonwealth, all call for a prompt curative instruction. This took a day and a half. And again, and I say this because even though trial counsel, defense counsel, did not ask the judge, or actually said, I don't think a curative instruction will help, the judge doesn't have to listen to him. The judges, I'll be the first one to say, you get to say so. Judges can can do that. And I think a better course would have been for the judge to at least give a preliminary curative. That obviously would not have precluded the judge from either allowing or denying a mistrial the next day. It would not have precluded the judge from giving the extensive instruction that he did the next day, which was a marvelous instruction. I totally admit that. But it's the fact that the delay was there. And I think that made the difference. There's a psychological example that I've heard many times. I don't know if the court has. But if you tell someone, I don't want you to live, whatever you do, do not think of the word elephant today. You can't not. In fact, probably the next time I come in here, you'll still say, oh, there's the elephant guy. But the point is, when you let somebody silence and let them ruminate about it, they think more about that than they would if you had just come out with something. And I believe that's what made it. I think initially, it probably wasn't warranting a mistrial. But the fact the jury was just sent out, and then, of course, the next day, everybody did in my humble opinion, did a great job as far as arguing it back and forth and all that. But again, the jury's still sitting there.
And there was no question, Mr. Kelly, it was inadvertent, correct?
I would, if that's what everybody says, that's what I would go to. I have my own little prejudice about that. Well, even if it was inadvertent, you still prejudice the.
Well, no, inadvertent isn't.
It's kind of like murder versus, voluntary manslaughter. The person's still dead.
Your point is well taken.
And in this particular case, and again, recognizing the elephant in the room, there's the elephant again, sorry, that he lied about having sex with her. Other than that, there was no fingerprints, there was no hostility, there was nothing else that put the two together. So I would say the Commonwealth's case is not their strongest.
Well, can we go back to the mistrial?
Yes, Your Honor.
So you make a good point about the benefits and drawbacks of the curative instruction. Our law is that we expect that jurors follow instructions, but nonetheless, it's a reasonable point to have that concern. Now, Judge Muse has a defense attorney whose initial position is that the defendant doesn't want it. Isn't he just being careful and having everybody have time to think through this issue? And I know it's not dispositive to be respectful of defense counsel's strategy, but some deference to defense counsel's position is probably a good place to start.
Are we talking the mistrial?
Exactly, yeah, because defense counsel doesn't want it, right? Initially. The curative instruction.
Okay. No, well, the defense counsel, right, the defense counsel
Okay.
did, well, the reason, and I think I would argue that there's no fault on the defense counsel to say that he doesn't want a curative instruction. It's almost that, like when they want an all or nothing verdict. I don't want a second degree. It's either going to be murder one or I'm not guilty. Similar and by analogy, the same way in mistrial or nothing is what he says. And I think if he were to have asked for a curative instruction, that would have diluted his point of you can't cure this one. You just saw what you saw, you heard what you heard, and you can't do it. So I would say that was the rationale behind it. But again, as I said, the judge doesn't have to do what he said.
Oh, you're absolutely right. You're absolutely right. It's just a prudent place to start would be to give some serious consideration to defense counsel's strategic concern.
Well, that's why I said to you, Your Honor, I just think a preliminary, anything, as opposed to just silence, would have been warranted there, and then could have gone back and done what they did, reflect on it properly, but at least the jury wouldn't be sitting there wondering. And I see my time is up. If there are no more other questions, I will rest on the brief.
Thank you.
Thank you, Your Honors.
Okay, Attorney Campbell.
Good morning. May it please the court. Julianne Campbell on behalf of the Commonwealth. Seated with me today is ADA Craig Iannini, who is lead trial counsel for the Commonwealth below. We're asking that this court affirm the defendant's conviction for the 1987 murder of Ms. Dora Brimage. I'd like to first turn to the sufficiency issue that my brother raised in his brief. And I'd suggest that in the light most favorable to the Commonwealth, the evidence demonstrated, and particularly in Exhibit 2, that the victim was found sexually posed with her pants and underwear around one ankle, exposing her genitals in a pool of her own blood on top of wallboard in a construction site
So
with
in
pieces.
Commonwealth versus Cessny, the victim was found on the side of the road. Her pants and underwear were pulled down, and she was strangled to death. The defendant's DNA was on the hip. This court found sufficient evidence for premeditation and atrocity or cruelty, but found insufficient evidence of aggravated rape to support felony murder. How is this case, and we may disagree with Cessny, given the evidence, but we have to grapple with the holding in Cessny. How is this case different?
Certainly, and I apologize to the court for not including the case in my brief. As Your Honor pointed out, neither, it was not raised in the defendant's either. I would ask for an opportunity to distinguish that for the court in writing, but I would say that here what is compelling is two pieces of what do amount to consciousness of guilt evidence. It's not simply that the defendant affirmatively denied ever having sex with the victim, which I think is significant, but it's that the way his story changed was that in the original investigation in the 80s, he informed law enforcement that he had dropped her off near Dudley Station, and 30 years later, he informs law enforcement that he dropped her off at Georgia Street. And Georgia Street here is significant because the entrance to where this victim's dead body was found was accessed via Georgia Street, and both the maps introduced into evidence and
So, and I have to ask a somewhat indelicate question, and I apologize. There's no evidence here that the victim was a prostitute, correct?
no, but what was in evidence was the defendant's. Yes.
I say that with all due respect to the victim and the victim's
Yes.
family, because that was a factor in Cessny, and now whether or not that's a legitimate factor, maybe it's for another day or still this court, whether or not that survives, we'll see. But that's not an issue in this case, correct?
Correct, Your Honor. And in fact, I will say the Commonwealth put that evidence in as evidence of how the defendant viewed the victim. He also turned the detective's attention in 2014 to, he happened to recall, although despite not remembering the victim off the bat, happened to know her boyfriend and suggested that her boyfriend used to beat women. So there were multiple things in the defendant's interview that I would suggest amount to strong.
You'll have an opportunity to distinguish Cessny, but
Thank you.
What you're saying is that this case is stronger because of the consciousness of guilt evidence primarily.
Yes.
And
yes.
how about the
Before we
condition?
Before we leave Cessny, could I ask, are you still on Cessny, or are you
Yeah.
going?
You go first, please.
So Cessny, one thing, again, another indelicate question, but one that may be necessary to address is there's no drainage in Cessny. They don't discuss the fact that the sperm I guess there's no drainage in this case. There's drainage that's not addressed in Cessny. Is that potentially significant?
It is from the Commonwealth's perspective, because from the Commonwealth's perspective, it indicates that the defendant deposited his semen inside of the victim at the place she was murdered. And I think that is a reasonable inference, and this sort of delves into another issue raised in the brief.
But how does it deal with aggravated rape versus consent? Would it have any significance there that she never got up?
Your Honor, given the way the victim's body was found, and I think the photographs establish that, and there's testimony that pieces of the murder weapon are in her hair. It's the Commonwealth's contention that through use of, she was found, cause of death was either strangulation or bludgeoning, essentially. It's the Commonwealth's perspective that use of force via the murder weapon, which was a shovel that had broken off into both her hair and pieces were by her body. It's the Commonwealth's position that given how her body was sexually posed, the lack of semen in her underwear, and the murder weapons that were used, which the Commonwealth would contend was what compelled by force the sexual intercourse.
And what about the condition of her head? Her face?
Yes, Your Honor, I do believe that I would urge this court to look at the photographs in this case. Her face was unrecognizable. Essentially, she did not really even have a face, given how bludgeoned it had been with
And
the murder
does that allow for a reasonable inference of lack of consent?
The Commonwealth contends, yes, strongly. If there are
Could
no...
you explain that, just the logic? Because we understand it's obvious proof of, first-degree murder, but I'm trying to understand how it's proof of rape, meaning that he's covering up?
Yes.
Okay.
That's part of it. But again, it's the evidence that was recovered here is the simplest way that I can put it, compels the strong inference coupled with the defendant's consciousness of guilt and other evidence they were seen leaving together, et cetera. That evidence is what demonstrates that the sex and the murder was part and parcel of the same event.
That's the problem with Cessny.
Certainly.
A heinous killing of a female and the sexualized nature of how the victim is found, in Cessny at least, did not lead to aggravated rape.
Certainly, Your Honor, but here, as I say, the fact that there is no semen in this victim's underwear and that
And
the...
in Cessny, there was DNA on the victim's hip as well. But we'll let you move on and
Well, I think, and I'm happy to, but because it's addressed in another area of my defendant's brief, I think it's critical. The fact that her underwear is around her ankle and does not have semen in it, I suggest begs
Well,
the reasonable...
that's the issue on the closing argument about whether or not,
Yes.
because Judge Muse did not allow the chemist to testify to this, and basically the discussion was we'll take this up later, and it was never taken up later, and then there was a closing argument of that she never had a chance to put the underwear back on, never got off the floor. And that was the whole drainage issue.
If I may just explicitly cite to the record, Your Honor, on page 162, it's of the transcript, I believe it's volume 3, but it's the March 9th date of trial. At page 162, the expert witness, Kevin Kishore, testifies that he will check underwear for drainage, and he explains drainage is when semen would flow into the underwear.
Right, but then doesn't Judge Muse say, no, you need a gynecologist, you're not going to be able to do this?
But what I think is important is that at page 49 of that same volume, where they're discussing this, the Commonwealth says, well, maybe I can't, you may not permit my expert to explain that beyond what he already did. However, I would suggest it was a reasonable inference that she didn't stand up after sex. And the court, Judge Muse explicitly stated at page 49, I think you're right, but we'll address that at another point in time. And I would suggest that it is a reasonable inference that she did not stand up after the defendant deposited his semen inside of her. And I'd suggest it's reasonable based on the fact that heterosexual couples engage in intercourse. It's a practice that I would suggest most adults are familiar with. And even beyond that, I'd suggest that the fact of touching cloth to a liquid, that it would leave a stain, that is as common sense and as commonplace as anything. And so I would suggest it absolutely was a reasonable inference for the prosecutor to so argue in closing.
May I ask you, suppose she did stand up, what difference would that make to the case?
I think the Commonwealth would be, if there was any indication of semen in the underwear or that she had stood up or moved, I would suggest that it would, the Commonwealth would be in a much tougher position to try and argue sufficiency of the evidence, because it would be more difficult for the Commonwealth to prove that that sex was part and parcel of the murder there.
Because of the 12-hour issue.
Yes. Unless there are further questions on that issue, I'm happy to turn to the consciousness of guilt instruction. I'm aware of no case that says that, well, two things. A judge is simply not required to give a consciousness of guilt instruction. I would suggest he certainly wasn't required to here where the defendant explicitly objected to such an instruction. And I would add that I'm aware of no case that has found it was manifestly unreasonable for trial counsel to make such a strategic decision. I think it's entirely possible that the trial counsel recognized that this was a fact that he would have to deal with, and he did, and he indicated. That's what people do if someone's asking about an old murder and they're coming to you. And it's entirely possible that because that's not, I would suggest, a very compelling argument, that he did not want the judge to further instruct on what the permissible consciousness of guilt inferences may have been, which the Commonwealth did argue in closing.
Isn't that why, unlike missing witness instruction and more analogous to Bowden, that having this be a mandatory instruction takes the opportunity for the judge to consider the particular case and the particular request of counsel?
It does, and I actually believe that at one point in the Commonwealth of Massachusetts, it was required, I believe, given certain circumstances, but this court had decided that's not the case for that very reason, Justice Lowe. It takes away the power of trial counsel to make those strategic decisions. That certainly hindsight is 20/20, and the defendant may have obtained a better result. But in any event, I'd suggest there really is no prejudice, because I think that instruction is, as Justice Gaziano said, essentially a fairly neutral instruction, although it may emphasize, the evidence that defense counsel would not want emphasized, given that the court would have to explicitly delineate what that evidence amounted to. Unless there are further questions, I will turn to the mistrial issue next. Quite simply, I'd suggest that Judge Muse did not abuse his discretion in declining to order a mistrial here. And I'll turn to the issue of promptness first, because my brother does raise that. Here, I want to point two things out to the court. Again, on that I believe it's March 9th, it's trial transcript 3, at page 208, the defendant requested that the judge not comment on the improperly admitted evidence before discharging the jury. And the reason the jury had been discharged were to give counsel the time to make arguments and to further research the issue so that Judge Muse, in his discretion, could make a well-informed decision. So while the term promptness is used in the case law, it was the first thing the jury was instructed on once they came back. And I'd suggest where the defendant specifically asked the judge to not comment on it before discharging and before further arguments from the parties, that this was a prompt curative instruction.
Well, that's an interesting point, whether it is or it isn't, because thank you for pointing that out. So after you have the issue come up, I think if I'm remembering, I looked at the transcript, that they're dismissed, and then the next morning they go through this for quite a while, and the judge finally brings them back, apologizes for the delay, explains it, and then gives an excellent curative instruction. So there's a question of whether that's even not prompt. I don't know the answer, but there's a question.
And I would suggest that this court must conclude that that is prompt, because otherwise the trial judge is in a position where he's not getting the benefit of reasoned argument and support from trial counsel.
And also to have a chance to do a little research, maybe?
Correct, Your Honor. If there are no further questions on the mistrial evidence, I'd simply ask that this court not reduce the verdict under 33E, given the serious and heinous nature of the murder of Ms. Dora Brimage.
Okay,
And I'll
thank
rest on
you.
my brief. Thank you.